Welcome to Legal Talk, a program brought to you by the law firm of O'Donnell, Weiss and Mattei, PC. We are a firm with offices in Phoenixville and Pottstown. We have a general practice with attorneys concentrating in specific areas of the law. One of those attorneys is here with us. I am David Kaplan, and with me is Victoria Hollister. Vicki, welcome. We're actually talking today about marital agreements, and Vicki's concentrating her practice in family law, or marital law, or whatever people call it. And premarital and postnuptial agreements are the two basic areas where people have agreements in marriages. Is that not true?
Right, that's true. But first of all, David, I just want to say congratulations to you. David just became a grandfather.
Oh, thank you very much. That's thank you.
That's a good family
That's
thing
a good, and there are many good family events. And actually it's a good segue into this because marital agreements are not always negative.
Right.
And so if you start with the premarital or prenuptial.
Prenuptial, premarital, yeah. Either.
If you do that, that's not necessarily a negative type of document. In fact, it could be very positive for both sides.
Right. I think that people have generally looked at prenups as being negative. They're getting married, they're happy, they're in love, they're not thinking about divorce. But really, a marriage is sort of a business arrangement. And to be practical, a prenup will help you determine how that arrangement will work if, in fact, the marriage doesn't work out.
So how often do you see prenuptial, premarital agreements? If you take 100 marriages, how many of them would have a prenuptial agreement?
There's a difference. If it's a first marriage, if it's young people, they're pretty much on an equal financial setting. They're same education. They aren't bringing much into the marriage. In those cases, it's fairly rare. In those cases, you would probably see it, and people could probably benefit from it, mostly if, say, one of the parties is expecting a large inheritance or large gifting from the family, those types of things. But in those situations, we don't often see it. We see it more often in second marriages where people are older. They may have established a business. They may have considerable assets that they're bringing into the marriage. That's when you see it more frequently, and maybe 30-40% of the time, I believe, the statistics that I've read.
Okay, and of course there are issues if you have children.
Yes.
From a prior marriage and wanting to protect them. And often that blended marriage issue is one that people take a look at and say, okay, I trust this new spouse, him, her, but I'm not quite sure. My children, actually the children many times are more concerned than the parent entering into the new marriage, what would be the stepchildren.
Right. They want to make sure that those assets are preserved for them.
Right.
And which is often the case. That's often one of the main reasons for entering into a prenup, is to preserve assets for children from a prior marriage.
So what goes into? I should go back, and there are also cases, are there not, where someone hasn't been married before, but again, usually a more mature, slightly older first marriage, where someone, again, similar to what you said, person has a business,
Right.
has been in either, maybe they've built a business or they're in a family business, and there are issues there, and they want to make sure that if something happens in this new marriage, it doesn't work out, it doesn't impact that
Right.
business. Okay.
So, if you don't have a prenup, the thing is and you do have a divorce, then the divorce code of Pennsylvania is what controls how your property is going to be divided, how your debts are going to be divided. And that's another reason for a prenup, to protect yourself from the debts of the other party as well. Not just protect your own assets, but protect, from debts the other party might bring into the marriage. So, but if you get divorced without a prenup, you have no control over what happens. And I think if people look at it that way, I can control what happens. And you can have certain contingencies for if A or B happens down the road in a number of years, then C will take effect, for example.
So let's play out a scenario. People decide it's time for a prenuptial agreement, okay?
Okay.
And first of all, who comes in? Does the husband or the future husband or future wife, or do they come in often? Do they sometimes come in together?
I believe they do. I've been fortunate enough to be able to screen first. People want to come in together, but I explain that I can only represent one party, and I cannot meet with both of them. So they're often surprised about that because they think, well, but this is an agreement we're making. Yes, but we are still representing that person and their interest in this contract.
So any time there's a potential of an adversarial relationship, even though it may not be there at the moment, the very
Yes.
fact that there's the potential of that, the law says ethically that we cannot represent both sides on that.
Correct, yeah.
And if someone comes in, if a man and woman come in, or two men, two women, whatever, who are entering into a relationship, and they say, we want you to do this agreement, you have to very quickly say, okay, which one am I representing?
Right.
And the other one, sorry, you're a very nice person, but now you have to
wait.
remove yourself, and we can only represent the one, correct?
Right.
All right.
Now, it's possible that the other person isn't represented at all, but we do try to encourage both parties to have counsel.
I know one of the things we put in both prenuptial and marital agreements is that if you have representation, you say who it is, you represent the one party, someone else represents the other party.
Right.
If you don't have that, you always have a clause in there covering that, don't you?
Yeah, we say something to the effect that the other person has been advised that they can retain counsel to review their rights and this agreement, and they have chosen not to, and they are satisfied that there has been a full and fair disclosure, all the requirements of the agreement, and they're agreeing to that, or they waive their right to any further disclosure.
Or further appraisals and things of that nature.
Right.
Okay, so now we have the person who comes in and says, okay, I think I probably need an agreement. I'm going to enter into this marriage. What do you need from me? What do they need to bring into you?
What they need to provide is a list of their current assets and liabilities.
First and foremost.
Yes, because that's the financial disclosure that's required in the prenup or a postnup. Oftentimes they will bring in one for, say for example, I'm drafting the document and the other party decides not to be represented, then they will bring in the assets and liabilities list for both parties. Sometimes people often bring in a statement of what their current earnings are, but that isn't required for the agreement.
Okay, and so they bring that in, and then so that's the disclosure. And that's not just your client. That's actually both clients.
That's both clients,
yeah,
right.
both sides have to know.
Mm-hmm.
Once they have that in front of them, I guess, do you discuss with your client what could and might happen, in fact, if there's eventually a divorce, separation? So what the potential issues are.
Right. Yeah, and how that property might be divided. If it's marital property now, any increase in value, or I mean, if it's non-marital, any increase in value could be marital. It could be absorbed into the marriage over a period of time. That you want to specify which assets will remain their separate assets.
So to most people, and I think this is fair to say, most people really don't know the difference between what are marital assets, non-marital assets in a marriage, and what issues involve the appreciation of property. And these are things you address in your prenuptial agreement.
Right.
How is that to be treated? Okay.
Yes, yeah. And other issues too, like alimony, for example, is something that is often included or excluded for both parties. Now, for premarital, prenups, the two areas that generally wouldn't be enforced would be any provisions for child support or child custody, because that's just too speculative, and custody is always going to be best interest of the child, and support's going to be based on current incomes.
Income at that time.
And we don't
yeah.
even know if there will be children, how many children, and so those things are generally not included.
So clearly in the prenuptial, you're discussing what happens if there's a separation, if there's a divorce, how things will be cared for, including, I guess, assets that are accumulated during the marriage.
Yes. Mm-hmm.
So, and you can actually, in equitable distribution, which is what happens in divorce, you don't know whether it's going to be 50-50, 45-55, 60-40. You don't know.
Right.
But you can, in a prenuptial, actually say, look, those things that we're defining, and you define it in your agreement, that are marital, that's what they'll be divided. But we're going to say right now how they're going to be divided.
How they're going to be divided. And you also can take a look at, well, what about future assets that we acquire? Well, if there's real estate, for example, well, if you title it jointly, that'll be considered marital regardless of where the funds originated. Or if it's taken from one of the parties' separate property, that new property will be their separate property as well. I mean, you can just figure out any way you want.
So you can shape it as you wish, as the parties wish, and you're not destroying the law. What you're doing is the law says this is what happens if and when there's a divorce and there's no agreement. But if in fact you do have an agreement and you've decided beyond the law, I mean, you're not being an outlaw, but if you decide beyond what the specific provisions of the equitable distribution might be, or alimony, or anything like that might be, you can specify in advance what it's going to be.
And that's so important that people have that control, because when you go into a divorce situation, oftentimes there's no agreement. You go before a master who takes a look at everything and, makes very major decisions about the rest of your life, your financial life. So this gives people control, and you can avoid a lot of the problems of divorce.
Vicki, I think we should take a break now to hear from our sponsors, and we'll come back and talk about the postnuptial agreement and actually some of what goes into making these decisions, okay, and why these agreements are enforceable. All right, so we'll see you soon.
For over 50 years now, O'Donnell, Weiss, and Mattei have helped their clients resolve a wide variety of legal challenges. OWM Law provides legal representation to clients throughout southeastern Pennsylvania. The attorneys and highly trained support staff utilize the latest technology and resources available to satisfy the needs of their clients. O'Donnell, Weiss, and Mattei, delivering the highest level of professional service.
Welcome back to Legal Talk, brought to you by O'Donnell, Weiss, and Mattei, PC. You can visit us on the internet at www.owmlaw.com. And today we're talking about marital agreements. With me is Victoria Hollister, who concentrates her practice in family law. We have spent the first part of the program talking primarily about prenuptial agreements. And Vicki, I wanted to hop over to the other part of it, and that is agreements after marriage.
Right.
And so postnuptial agreements, and do they all happen when people are getting divorced? Is that when you have all your postnuptial agreements? Or?
No, not necessarily. I would say the majority of them come about because people are divorcing. But there are other situations where a person maybe didn't feel the need for a prenup, but things changed, and they now feel that there are certain assets maybe that they want to exclude as marital assets. For instance, if a person is going into a family business, well, maybe the parents who run the business, they don't want that business becoming marital property if their son or daughter happens to divorce. So you could enter into a postnup for that purpose alone, excluding that business interest as marital property in the case of divorce.
So even though it's a good solid marriage, the family doesn't know. You never know. These things after what percentage of marriages end in divorce?
50%.
About 50%. Okay.
Slightly less, I think, for first and more for second and third.
Really?
Yeah.
Okay. It's a high percentage.
Yes.
So families should be concerned about that if someone's going into a family business, and I guess there are other specific assets that you might want to exclude. You just may say this asset just can't go in here.
Yeah.
Okay. But then most of the postnuptial agreements are involved when people are separating and getting a divorce. Is that true?
Yes.
And is that how common is it? We said in prenuptial agreements that unfortunately it should be more common, but it's not that common. How about in postnuptial agreements?
I'd say the majority, fairly good majority, end up with an agreement. I think most people realize that if they have to go to court, it's going to be even more time, even more money, and they lose any control that they now have over how things are going to be divided, whether there will be alimony or not. So we try to encourage, of course, our clients to enter into an agreement that's fair and sort of takes care of both parties.
So I know some people say, look, I don't have much. Why do I need an agreement? Why do they need an agreement when they don't have too much?
Well, just so that they know what's theirs and what isn't. I mean, even things like cars, you have to change titles, and real estate, you have to take it out of joint names. Whatever it is, you.
So even in a postnuptial agreement where there's not a lot, there are still usually things that have to be done. There's some, even though you may not have a large retirement plan.
Right.
And you say, okay, you can have yours, I'll keep mine. That issue can come up.
Right.
And so it's important to get it out of the way.
Yeah, I know a lot of people think, well, it's my retirement plan. Well, it's his retirement plan. Well, no, actually, anything that's acquired during marriage is marital. I mean, it's funny that people don't look at the marital residence that way, but they do have a tendency to look at retirement plans as this one's mine and this one is theirs. But, we have to explain that no, anything that you acquire during marriage is marital.
And I'm sure you've had people who have come in and said, that's my car. and he said, I could keep that car, and now we're divorced, and our names are both on it, he won't sign that darn title.
Yep.
And, you know, on the face of it, it's both of theirs.
Right.
Because it's still titled in both names. And they never entered into an agreement. They didn't have much.
Yeah.
They could have had even a short agreement, something that specified.
Yeah, I mean, I know people have come to me and say, well, it's just going to be a quick divorce. We don't have anything to divide. We just have to get divorced. But then I say, well, do either of you have a 401k? Well, yeah, they have 401k. Do you have cars? Yeah, you know, and those things often come up and say, well, those things have to be determined how they're going to be divided. Even if you keep your retirement and the other party keeps theirs, it at least has to be specified, right, because you could later have a claim against that.
Okay. So the postnuptial agreement goes into specifics as to all assets.
Yeah.
And specifies which go where and how they're to be divided.
And also debt, the credit card debt.
I keep on saying assets, but debt as well. It's part of the picture. And this is somewhat the same as we do in the prenuptial agreement in terms of getting all the facts out and deciding what's going to be done, except a little bit harder at this point, usually. And it also, sometimes you deal with, in this case, custody issues and support issues,
right,
as well as alimony and all of that.
Yes.
Okay.
Yeah. Oftentimes the issues involving the children are included in the postnups or marriage settlement agreements, as we often call them, or property settlement agreements.
Okay. So all this goes back to a question of, I have an agreement. Is it enforceable? And maybe that's something that the general audience doesn't think about. Sure, I have an agreement that says it. Is it enforceable? That was it's less of an issue now than it used to be.
Right. Yeah, it used to be with prenups and even postnups that they tended to look at women as a more dependent spouse, and to protect a woman in a divorce situation. And there was a requirement that any agreement that person had to have knowledge of what the law was, what their statutory rights were. And but then that changed.
Yeah, there was a famous case
that changed it.
Before that,
Geyer.
The Geyer case that gave us a lot of that outline, and then the law started to change. And
right.
You and I discussed this before coming on the air a little bit. That it's interesting. 1971.
Yep.
Pennsylvania passed its own Equal Rights Amendment.
Right.
And we are one of about 24 states, I think,
yeah,
that have some form of ERA. There was a federal ERA that was passed by Congress, which would have amended the U.S. Constitution, and actually never passed enough states.
States, right.
And so it never became a part of the U.S. Constitution. It is the Pennsylvania Equal Rights Amendment to our Constitution,
right,
that put men and women on an equal status. And it helped women in many ways with employment in Pennsylvania, but it also helped men in many ways in bringing them to an equal status, especially in divorce matters.
Yes.
There's a big change in custody and all that. And eventually, took a while. That was 1971. Eventually, that filtered down to a major change in Pennsylvania law. It came from the Supreme Court in a case. You want to talk?
Simeone, yes, the Simeone case, and that was about 1990,
yes,
I believe. So It was almost like 20 years later, and the Simeone case was well, actually, our divorce code changed in 1980, and it was sort of a very radical change from the way it had been prior. It always had fault divorce. This was the beginning of no fault divorce. So anyway, this agreement was actually an agreement prior to the the amendment to the divorce code, and it involved alimony. But what it stands for more than that is the fact that prior, the dependent spouse had to have knowledge of the statute and what they were giving up. And Simeon said, no, we have an equal rights amendment to our Constitution, and women are treated the same as men. This is a contract that, she has the ability to get a lawyer and the same way a man does, so she's not getting any special protection.
So when you and I went to law school, we learned basic contract law about you had to have a knowledge of what you were buying and selling, and there was a lot. There has to be
meeting of the minds,
consideration, all that stuff, and those were the elements of a basic contract.
Right.
And so long as those basic elements were met, even though the buyer or the seller did something foolish, bad deal, it was on you.
Yep.
Buyer beware type of thing.
Right.
And so that became the standard in marital contracts as well.
Yes.
As Simeon, okay. And Simeon dealt with a prenuptial agreement, but it was then applied to postnuptial agreements.
Yeah, the same standard now applies. And that's why we generally put in the agreements the fact that someone has had the opportunity to meet with counsel and understand their rights and review this document and so on, so they can't later say, because there are three ways that you can set it aside. It would be fraud, misrepresentation, or duress. So
let me just jump in on that. You say duress. So two people are about to be married. They've never really discussed in any detail prenuptial agreement. And it's wedding day. And one comes in with a piece of paper saying, I've been thinking about this, and I had my lawyer draw up an agreement for us. The people are already assembling for the ceremony, and I haven't had a chance to even look at this darn thing. And what are you asking for? Oh, it's nothing. And you're just, is that going to be valid?
I would think that would be duress.
Okay.
That would be an example of duress. Well, it's funny because in Simeon, the spouse brought that up, that she didn't know prior. She was basically given this the night before, this agreement to sign, or the day of, something like that. But there was testimony from other people that, no, in fact, she had had this for several weeks. She was aware of it. She chose not to do anything about it. So that changed the situation.
She made it a last-minute type of thing.
Yes.
Yeah. Yeah, I know I tried a case involving a postnuptial agreement where my client ended up with maybe 80% of the assets, and the judge raised his eyebrows a little bit and said, how did you make this fly? And there was a reason why it ended up that way. And we were able to show that I happened to represent the husband in that case, that the wife actually was one who maintained all the books, who knew all the assets, who knew the value of everything, and knew specifically what she was giving up, and had every opportunity to review it, and chose not to get an attorney when she signed the entire document. So, and so it was enforceable, even though it was a lopsided agreement. Okay.
Yeah.
All right. Well, thank you, Vicki. It's been very informative. And it's something that many people say, well, I really don't want to even look or talk about. It's not me, but it may be you. It may be your children, grandchildren, whatever, that are looking at relationships. And you want to stay out of court, frankly. We don't like to be trying these cases if we can resolve things in a better way.
Yeah.
Okay. Thank you. And thank you, Victoria Hollister.
Thank you, David.
We'll see you soon.